Hello friends, how are you? Today I am going to discuss an important topic concerning the Negotiable Instrument Act and the Acquittal. Along with the same, I will also emphasize on the importance of the income tax return in winning the negotiable instrument case. Friends, as we know that there are divergent views. Some view says that if the check is executed by the accused, in that scenario there is a presumption of section 139 of the NI Act. The contrary is required to be proved by the concerned accused that the check is not given towards a legal enforceable debt. While some views are that the concerned complainant is duly bound to prove the case, and even he is required to specify the source of lending. If he fail to do so, the same will be an unaccounted money, and unaccounted money does not come within the preview of legal enforceable debt. So all this controversy has been finally resolved by the Hon'ble Supreme Court in its recent verdict, wherein the Hon'ble Supreme Court has interpreted Section 138 of the NI Act, read with Section 139 of the NI Act, with the provision of the income tax as well. So, we have to be aware about our rights. If your rights are going to be affected, then no one will cure it. So, this video is quite useful to you, so that if you are having the same problem, you may encounter the same and could enforce your right as per the law. Friends, first note down the name of judgment. It is Rajaram versus Marutachalam. Judgment is passed by the Honorable Apex Court on 18th of Jan 2023. In the judgment, at head note, it is specified that the standard of proof for rebuting the presumption is that the preponderance of the probability. Once the execution of check is admitted, Section 138 of the NI Act mandated a presumption that the check was for the discharge of a debt or legal enforceable liability. But it is a rebuttable presumption, and onus is on the accused to raise the provable defense. The standard of proof for rebutting the presumption is the preponderance of the probability, and it is open for the accused to rely on the evidence led by him or to raise the probable defense. The interference of probability can be drawn not only from the material brought on the record by the party but also by reference to the circumstances upon which they rely. So this is the important contentions by the Honorable Supreme Court. Apart from that, as far as Section 378 of the CRPC is concerned, the Honorable Apex Court also specified the scope regarding lying of appeal, and apart from that, the Honorable Supreme Court also specified that the standard of proof in the criminal proceeding and civil proceedings are quite different. In criminal proceeding, the concerned complainant is required to prove the case beyond the reasonable doubt, as per Section 101 of the Indian Evidence Act, while in the civil litigation, it is required to prove the case by preponderance of the probability. So now I am coming on the facts of the case. In the present case, the accused has been convicted under Section 138 of the NI Act. He has preferred the criminal appeal before the Honorable Supreme Court. The prime contention is that there is no legal enforceable debt, and that's why the entire case is totally bogus and abuse of process and liable to be dismissed in toto. The basic factual matrix is that in the year of 1992, the appellant Rajaram, who is an accused in the case, whose wife has subscribed to a 5-year chit fund with one Marutachalam, the respondent in the present case. He is of persuasion that in order to be a successful bidder, a security by the way of blank check must be submitted. And ultimately, the appellant submitted two signed blank checks bearing number 237954 and 237956 on behalf of his wife. Since she did not have a bank account, it is to be noted that the check were drawn on account of a concerned firm, the sole proprietorship of the appellant maintained with Lakshmi Vilas Bank Limited. Their contention is that in the year of 1995, his wife subscribed to yet another 5-year chit fund with the respondent Marutachalam. In the year of 1997, the bank account out of which the said checks has been issued were closed due to non-cooperation. The first chit was matured in the year of 1997. Since the wife of the appellant was not the successful bidder, that's why the appellant and his wife repeatedly requested the respondent to release the amount of the chits. And subsequently, another chit was matured in the year of 1999, and same request was made, but when the amount is not released, they inter alia demanded the check, and when the same is also not returned, they asked for the legal proceeding. And as a counterblast, the concerned respondent had misused the check, one through his brother-in-law and through by himself. When the check has been submitted, they were resident dishonored, and ultimately legal notice has been served, and finally he had filed the complaint. The complaint was dismissed by the concerned trial court because he had failed to specify the legal enforceable debt. Because the clinching point is that the concerned accused had summoned the income tax authority with the records of income tax return of the concerned complainant in which the alleged transaction has not been shown. And he had submitted that if the alleged transaction has not been shown, that could not be termed as legal enforceable transaction, and that's why no liability could be imposed as per section 138 of the NIA. To buttress his contention, he relied on the judgment of Hon'ble Supreme Court. The appeal was opposed by the respondent. He submitted that the check has been issued, there is a presumption, and he failed to rebut the presumption. And he relied on judgment of Bir Singh, Rohit Bhai, and Kalamani tax, etc. The inter alia, the Honorable Apex Court has interpreted section 118A and section 139 of the NIA Act, and also reproduced the same in the light of the legal position retrieved earlier. They have summarized that although the execution of the check inter alia attracts section 139 of the NIA Act, but it doesn't mean that the check is deemed to be proved. In order to prove the case, as far as the check is concerned, the onus is on the complainant. But apart from that, if the execution of check is not disputed, then the check is not towards any legal enforceable debt, or it is wrongly executed. The burden shifts on the concerned accused, and he has to raise the probable defense, and he could do so by raising a probable defense or by leading evidence in respect of material available on the record. And apart from that, the financial capacity of the complainant is quite important in these cases. And apart from that, the financial capacity of the complainant is quite important. The court is specified. And apart from that, in the present case, the income tax officer has been examined, who specified that the transaction has not been shown in the returns. Looking at the facts and circumstances, the court concluded that if the concerned complainant failed to show the alleged transaction in the income tax return, in that scenario, the legal enforceable debt does not exist, and the same could not be a ground to attract section 138 of the NIA Act as far as the penal provision is concerned. The Honorable Apex Court had accepted the appeal and inter alia declared the accused to be acquitted from all the charges. So it is an important update. So if you are having the same problem, don't worry. You just have to submit an application before the concerned court as per section 91 of the CRPC with a prayer to summon the income tax officer if there is an admission that the concerned complainant is an income taxpayer. Just ask for the PAN card number, just ask for the ward number, so that the document could be easily summoned. And if the complainant does not show the alleged transaction in the income tax as per his admission, or fail to submit the income tax return for the concerned financial year or assessment year, in that scenario, the things would be fatal and you could easily claim the acquittal, because the unaccounted money could not be a legal enforceable debt, and same could not be a basis for the prosecution under section 138 of the NIA. So it's an important legal update. Be aware for your rights, and definitely you will win. If you like this video, just share it. See you in the next topic. Till then, Jai Hind, Jai Bharat.